Hello, everybody. Welcome to the Swiss Patent Litigation Fireside Chat. It's the 35th edition already. It's been a while since we had the last session because I skipped the one end of December last year. I felt, well, not too many people are in the mood and have the time to discuss patent litigation things at the end of December. So I skipped the last session, which means that the agenda is pretty packed for the first session now. After 2 months, we had no reports on patent litigation on LinkedIn. So let's move directly in. So as always, I received some questions and input beforehand, but if during the session you have some comments, questions, please feel free to leave a comment on LinkedIn directly. I will have an eye on that and pick it up directly, or send me a comment by email or via LinkedIn afterwards. So I will stick pretty much to the agenda that I have shared upfront on LinkedIn. So the first case was a hearing that I attended end of last year. That was the 6th of November last year. You see the case numbers here. That was a typical ownership dispute, an assignment action, and a counterclaim for financial compensation if the patent applications would be assigned to the plaintiff. So assignment actions, ownership disputes are always, well, in a way, fun to watch, but they are always mud wrestling for the parties involved. So this case is not an exception to the rule, I think. The interesting part of that hearing, at least for me, was that I had to leave the courtroom for quite a while when the defendant essentially argued, hey, we are discussing ownership, to which party this patent application should belong. And in my pleadings, I will present arguments that certain pieces of the invention were already prior art, and that in a way would undermine the validity of the patent application or the patent if granted later. And so since validity is not at stake in that proceedings, this would be nothing that the public should have an interest in. So defendant asked or requested that I should leave the courtroom for this part of the pleadings, and indeed the president ordered me to leave the courtroom when it came to that point in the pleadings. I already said or wrote on the blogs that I was, well, a bit disappointed, because I think there is, if it was relevant for the question of ownership, what was already in the prior art as part of the invention, if that was relevant for the ownership case to decide, I think that's something where the public should have an interest in, or could at least join this part of the hearing. And if it was irrelevant, then the parties are free to stick to the relevant parts. So anyway, I had to leave the courtroom, and I hope that's not setting precedent for further cases. I have attended quite some hearings after that hearing already, and I was not ordered again for some dubious reasons to leave the courtroom after that. So I don't think it sets a precedent, but yeah, I'm just keeping an eye on that. So as I said, that hearing took place on the 6th of November. Nothing has surfaced since then. So I got the impression that the parties were not so far apart, so that a settlement may even be in reach, or has already been reached. At the end of the hearing, I had to leave the courtroom again because parties were discussing settlement. So it may well be that this case is settled already. Otherwise, I think we can expect a judgment soon, if nothing will be published in the next 2 to 3 months, I would say. Then this case has been settled. That would be at least my educated guess on that case. So the next case is, well, in fact, a part of a cluster of cases, so to say. It's about Rivaroxaban. That's a prescription blood thinner where the originator's product is Xarelto of Bayer. And yeah, there are, well, they are approaching the patent cliff. So that patent is about to lapse, I think, in January next year. And there is a lot of infringement disputes and nullity suits ongoing. So my firm is also involved in one case relating to Rivaroxaban. So I will be very brief in this cluster of cases, so to say. I attended the hearing in the case Rivaroxaban Sandoz. That was a hearing that took place in November, 11th of November last year. And from the case number 007 of 23, it's pretty clear that the case must have been filed around about mid 2023. So yeah, that was the main hearing. So after the conclusion of the written exchange of briefs and after the expert opinion of the judge rapporteur had been sent to the parties, and the parties had the chance to comment on the expert opinion. So it was already the main hearing, as I said. And from the main hearing, it was pretty clear that the expert opinion of the judge rapporteur was negative for Bayer, meaning that the patent was likely invalid. So it was an uphill battle for Bayer in the main hearing. And yeah, the president in the end concluded that they will render the judgment as soon as possible, as he said, but maybe not before Christmas. So Christmas is quite a while ago. So we are awaiting the judgment every day. By now it has not been published. But yeah, I think there is no chance that a settlement occurred in this cluster of cases. So yeah, we are eagerly awaiting the judgment. In that case, between Bayer and Sandoz. So that was a nullity case. So Sandoz filed a revocation action against Bayer for that patent. If you are interested in any details about the hearing or in more details about the hearing, that's already commented on my blog. So as I said, it's a cluster of cases. The other aspect of the currently publicly available litigation concerning Rivaroxaban is Rivaroxaban Helvepharm. Zentiva is, they are trading as Zentiva, and Helvepharm is the legal entity in Switzerland. So that was a pretty interesting case because in first instance proceedings that were summary proceedings at the Federal Patent Court, Helvepharm had filed a protective letter with the court. And only a few days after the protective letter had been filed with the Federal Patent Court, Bayer indeed requested a PI, preliminary injunction. And Bayer requested that the preliminary injunction be rendered ex parte. And in the first place, and of course then if Helvepharm was heard, that the PI was maintained afterwards. Now, what did the Federal Patent Court do with that? They considered the protective letter and they dismissed the request for an ex parte PI, which is perfectly fine. That is pretty much common sense. That has been done very often, meanwhile. But they also dismissed the PI as a whole in one go. So the PI was dismissed, and these whole summary proceedings were concluded. And Helvepharm was even awarded costs for the filing and work on the protective letter. So, of course, Bayer was not amused by that outcome. And they appealed to the Supreme Court. And the Supreme Court indeed now confirmed that this was pretty far-reaching. I called that on the blog a coup de main. So in essence, what the Supreme Court said was, yes, you can dismiss a PI request in one go if it's clearly inadmissible or clearly unallowable. But in a case where the court considers a protective letter and staffs a panel of judges with two technical judges and renders a decision with 23 pages, I think, on the merits, and this all indicates that this was not a case that was clearly inadmissible or clearly unallowable. So the Supreme Court concluded that the right to be heard was violated and lifted the Federal Patent Court decision, remitted it back to the Federal Patent Court in order to give buyer a chance to comment on the protective letter. Now, as I said, it's a cluster of cases. So I attended the main hearing in the Sandoz case that I mentioned a minute ago. And I, of course, have read the decision in the Helvepharm case, and the arguments and the evidence that is mentioned is the same. So merely from the timing, I think it's pretty clear that the court and also buyer knew a lot of the arguments, and that these arguments and the evidence was not only in the protective letter by Helvepharm, but quite likely has pretty much identically been pleaded already in the Sandoz case. But still, they are separate cases. And as I said, now the Supreme Court has remitted the case back to the Federal Patent Court to give buyer a chance to comment on the protective letter. And meanwhile, everybody is waiting for the judgment in the main proceedings about nullity of the patent, which then again might interestingly interfere with the summary proceedings in the Helvepharm case. But we shall see how that plays out time-wise. The next case that I wanted to briefly touch upon is a summary case, again, which is just a procedural order that has been issued here. The buzzword is Lisdexamfetamine. That is an active ingredient that is used to treat attention deficit hyperactivity disorder and I think binge eating disorder too. And the parties are Takeda. Takeda is a patentee, and the generic company that is sued for infringement, or where a PI is requested preliminary injunction, that is Spirik. On the defendant side, nothing interesting to report on the merits of the case, apart from the fact maybe that I very much love the patent claim, which is pretty straightforward and short. Anyway, that only happens in chemistry, I think. So the interesting part here is what the procedural order is all about. It says for the first time, and I read it out, that in proceedings concerning preliminary injunctions, the patent can only be asserted or defended in a single version. And what cannot be done accordingly is that you ask for a PI. Obviously, it should be an urgent case where you need intermediate injunctive relief. So everything is really a matter of speed, a matter of time. And the president held that it's inherently conflicting with that urgency that you are trying to let me put it provocative, to bother the court with various versions of the patent to be assessed in order to come up with an opinion whether it's valid. And the gist of that order is, hey, if it's really urgent, then make the request and also the version of the patent in which you assert it against the defendant as broad as necessary, but not broader, because you can litigate in main proceedings with a broader version anyway. But if time is of the essence, assert the patent to only to the extent possible. I think that is, or necessary, not to the extent possible, but to the extent necessary. In my understanding, what that practically means is that from now on, when the plaintiff is asked to submit the advance on costs after he has filed a PI request, that he's also asked to confirm which version of the patent is maintained. If with the PI, several versions were asserted. Yeah, there was a bit back and forth in that case. The plaintiff Takeda argued, "Hey, it's undue that you limit us in the way we are asserting our patent, while the defendant can bring each and every nullity argument at his free will. So there is no limit for the defendant." And plaintiff tried to restrict defendant to only arguments that were not already considered by the Board of Appeal of the EPO here, that held that the patent was valid. The president did not follow that argument. It would be an undue limitation for the defendant to only stick to the arguments that are new over what the Board of Appeal had already in front of them. So yeah, my opinion on that is, I like it, to be honest. Some summary proceedings were just as inflated as main proceedings, just with shortened time limits, which is not really the gist of PI proceedings. But that's just my very personal opinion on that. What remains to be seen is how that is then now lived actually by the court. I hope that it's only meant to limit the patentee in the way he starts his PI request. I don't think it would make much sense to limit the patentee's possibilities for the whole PI proceedings to only stick to one version of the patent. Meaning, if defendant presents a totally new nullity argument that has never been pleaded by anyone anywhere in the world, so that could not be anticipated by the one requesting a PI. So I think there should be some leeway for a patentee to at least then adapt his version of the patent in which he seeks interim injunctive relief. But that remains to be seen. The order is a bit vague, maybe intentionally vague in that respect, but that needs to be seen. So the next case is about a kind of rescue device for people that were hit by an avalanche, to find people that are buried under the snow. That is litigation between Mammut and Orthovox. We have the case number here. These parties know each other well from litigation, I think 10, 15 years ago. That was also about an avalanche rescue device. So these parties know each other. This is a nullity case. So Mammut is trying to get the patent of Orthovox revoked in Swiss nullity proceedings, and we knew that this case existed since quite a while from an order of the UPC. I think I have it on the next slide. Yeah, exactly. That's here. So that is a publication, I think, back in 2023 already, when PI proceedings were at stake at the UPC. So we even had the case number from the PI decision of the UPC, but nothing had surfaced since then, until the hearing at the Federal Patent Court, which took place on the 13th of January, not too long ago. I attended the main hearing, and it was pretty clear to me that the patent as granted was held invalid according to the judge rapporteur's expert opinion. And then I made a mistake in my first version of the blog post. I was pretty sure that the judge rapporteur's expert opinion was the same also for the auxiliary requests that Orthovox had filed, but I was wrong. I was told by Orthovox's representative that actually the judge rapporteur's expert opinion was the exact opposite for the auxiliary request. So his opinion was favorable for Orthovox, so all the auxiliary requests were held patentable by the judge rapporteur. So yeah, the main hearing was essentially again exchanging arguments for all the auxiliary requests, and the invention there. I did not mention that. I should have done so in the very beginning. So it's a combination of a kind of bleeps. These devices are bleeping depending on how near or how far you are away from the one to be rescued. And there is also a voice guidance, a voice message that guides you through the snow and guides you to the person to be rescued. And the bleeps are suppressed or reduced in volume when the voice message is output. So that's in a nutshell, very much simplified the invention here. And yeah, we are awaiting the judgment now on validity of that patent in Switzerland. Interestingly, what happened at the UPC in parallel was, I already said, and you see that still on the screen, that is from the ex parte PI that was issued by the local division in Düsseldorf of the UPC. That was 11th of December 23. And that order was confirmed after Mammut was heard. So in inter partes summary proceedings, that PI was confirmed. That one was published on the 9th of April last year. And it's one of the very first cases at the UPC that in summary proceedings even went up to the Court of Appeal. And the Court of Appeal also, for the time being, confirmed that this PI remains in place. So in my perception, what will be interesting to see is, and main proceedings, of course, are also pending at the UPC still. And I'm eagerly awaiting the outcome in main proceedings at the UPC, and then to compare it what the judgment in Switzerland says concerning validity. And the reason for that is the UPC, at least not explicitly, has not yet said that they will or can follow the problem solution approach of the EPO. They do something similar in my reading of the judgments, but they don't say they do it. So they have not yet committed to apply that problem solution approach, but the Swiss Federal Patent Court did. So when you look at the judgment of the Swiss Federal Patent Court, the whole validity arguments as a rule are according to the problem solution approach. So that might be an interesting case to really compare the outcome of two parallel proceedings with, I hope, pretty much essentially the same arguments and prior art being considered, whether it makes a difference in the outcome if the problem solution approach is applied or not, or applied without saying so. We shall see. So, which already brings me to the gossip section of the agenda. One thing is that I always watch the cases that have already been decided, whether anything happens on the market or to the companies involved, and I did so also with this case here. That is a case that was decided last year, and it had been appealed to the Supreme Court. The appeal proceedings are still pending. I think I have the order exactly. So part of the order was an obligation for the defendant 2, that was a company, to pay an amount of 75,000 Swiss francs to the plaintiff. And it was also a pretty messy ownership dispute. But here in that case, the patent court held that that was not just a co-invention, but it was a contractual relationship between the defendant and the plaintiff, and it was just a service rendered, and that service had to be refunded with 75,000 Swiss francs. So in the end, ownership still resided with defendant 2 of the patent application, but it had to pay 75,000 Swiss francs to the plaintiff. The plaintiff is the company that is here written on the left bottom side of the slide, CM Profiling, GmbH SARL. I looked that company up in the commercial register and on the website, and then what struck me was that the website of that company that marketed a certain product that was at stake there. So the website was offline. That made me digging further, and I looked for the company. And the company is apparently in liquidation, so it filed for bankruptcy. So practically, apparently the company does not have the funds to pay the 75,000 Swiss francs. That's my educated guess. Digging a bit further, then brought me to the Swiss patent register, and I maybe enlarge that. It's a bit tiny. So there is a new owner registered in Swiss Rec on the bottom left. That's Plenium, and on the right side there's the history. So CM Profiling transferred that Swiss part of the patent to a new owner, Plenium, and that transfer was registered on the 30th of December last year. Pretty interesting. So the patent is now no longer within the entity that was obliged to pay the 75,000 Swiss francs. So no money, no patent in that entity. At least that's what the Swiss Rec entry says. Now, meanwhile, at the EPO, there was also a request filed with the EPO to transfer the whole European patent for all contracting states to the new owner. But apparently there, the piece of evidence, the actual assignment deed, was not attached to the request to the EPO, and in parallel, the Konkursamt Bern, so the bankruptcy office of Bern, informed and inquired with the EPO, hey, which patent applications are around at the EPO? So the EPO knew that CM Profiling applied for bankruptcy, quite likely other than the Swiss Patent Office. So the request to transfer the whole European patent with effect for all member states is apparently stuck at the EPO, but not so for Switzerland. The Swiss Patent Office just registered it as requested. That might mean trouble, but that's just me reading the tea leaves here. So that's again part of the gossip section. There was a LinkedIn post by the Federal Patent Court inquiring what people thought about introducing a kind of countdown timer in order to make people aware that the first round of pleadings should only be lasting 1 hour. So the court always informs the parties upfront, hey, please restrict your initial pleadings to 1 hour, with mixed outcome. And to be very, very, very honest, it's not that I'm not part of the problem. I also participated in pleadings that lasted much longer than 1 hour. Sometimes it's really hard to limit your arguments to 1 hour. But still, there is this express wish of the court to limit the first round of pleadings to 1 hour. And in the second half of last year, I would say in some hearings, I got the impression that the president was, how can I put that, increasingly unpleased that attorneys, without even asking for it, just exceeded the 1 hour limit by far. So nothing happens without a cause. So here, that gives you a bit of background what the cause might have been for coming up with the idea of that countdown timer. So the court made a poll on LinkedIn what people thought about such a countdown timer, and the outcome at the face of it was pretty clear, saying 69% said yay, good idea, and 31% nay, with 59 votes that were actually casted. So the Federal Patent Court then reported about the results, and they, of course, had a chance to look who were the people voting. And with that knowledge, they could break down the results a bit further, and they concluded that only 36 votes were actually from people that realistically would ever plead at the Federal Patent Court. So no foreign votes from, I don't know, the UK or US attorneys who are maybe more used to such timers. Those votes were not counted, but only the 36 votes from people realistically ever pleading at the Federal Patent Court. And then the result was not so clear anymore. It was only 58% yay and 42% nay. So again, looking further into the voters groups, the Patent Court said patent attorneys like the idea a lot more than attorneys at law. The comment of the Federal Patent Court was, and I read it out, "We know who likes to talk much." If the patent court says that is the case, then so be it. My impression is at least not that patent attorneys are typically not the ones who are on the length on the shorter side. We can talk a lot if need be, and yeah, that was pretty much the comment of the Federal Patent Court. Now, what's to expect? The Federal Patent Court left that open and said we will decide whether to introduce a clock. And now the interesting part is taking into account all circumstances, also future developments. So I think that's a kind of polite warning to the attorneys and patent attorneys. Please limit your pleadings to 1 hour, or if you can't do that, please make a note upfront and do not just exceed the time and plead 2 or 2.5 hours without even asking for permission. So if future developments will still show that parties just don't care, I think we might see this clock in action. Otherwise, I got the impression that the Federal Patent Court has a slight hope that it's not needed to put that clock in action. So we shall see. So that is the Higher Regional Court of Düsseldorf, the building of the Higher Regional Court in Düsseldorf. I'm having that picture here, not because it's a Higher Regional Court building of Düsseldorf, but because it's the seat of the local chamber, local division of the UPC. And there was an interesting judgment yesterday issued by that local division, which made me wondering whether that could also have an impact on Switzerland. It quite likely can have. So that judgment was, I think it was litigation between Fujifilm and Kodak. And the local division Düsseldorf held Well, if the defendant is located in a contracting state of the UPC, then we have long-arm jurisdiction to also rule an infringement for the UK. So if that is confirmed, and I think that will be challenged with quite some likelihood up to the Court of Appeal, but if that is confirmed in the end, then there is no reason to assume why that should not also apply to Switzerland. So there may well be judgments where a defendant is being sued in Germany because the defendant is based in Germany, and that an infringement judgment of the UPC can also be rendered with effect to Switzerland. I was just thinking, and I've not finished with thinking, to be honest, whether the Federal Patent Court could maybe also have long-arm jurisdictions for issuing infringement judgments, for instance, to the territory of the UPC, to Germany. Why not? From the top of my head, I cannot recall a judgment of the Federal Patent Court dealing with that question, but maybe it just needs a brave attorney to try that. Maybe that could work. Which brings me to actually a question that I have been asked up front. That colleague was asking me, hey, you mentioned that you are trying to get hold of the dossier concerning appeal proceedings for a rejection of an SPC application at the Federal Patent Office. And what happened to that case? The simple answer is I have no idea. It's dormant. So yes, it's true. I went to the administrative court and I appealed that decision to not hand over the dossier of the appeal proceedings. And that appeal is from March 23, I think, March 23. The written exchange of briefs was concluded, I think, around about October. Of course, I tried to have a public hearing of that case, which was rejected. No hearings at the administrative court. That's rare as well. That's rare. I put it like that. So that was end of 23 when that was already done, and since then I haven't heard anything. So it's almost 2 years that I lodged that appeal, and I have no idea what's happening. But yeah, one day or the other, I think I will learn whether I get this part of the file or not. My argument, in essence, is that's an interesting part of whether an SPC is granted in Switzerland or not. The proceedings at the Federal Patent Court are quick and concise. And then the appeal proceedings at the administrative court, this is where the interesting part happens, where much more arguments are presented and where you learn why things are maybe held differently concerning the outcome than compared to the situation in the European Union. And that was definitely the case here. And it's not that the Federal Patent Office is just a Zaungast. I don't have an English word for that. It's a party involved in the appeal proceedings. So actually half of the dossier that I was requesting was written by the Federal Patent Office, but they still refused to hand it over as part of the dossier of the SPC application that they have in their hands. And I felt that was wrong, and sometimes I'm stubborn, and we shall see. So, which brings me to another part of the gossip section, that is this case here. That was actually a hearing that I reported on my blog about pretty extensively. That was a hearing of March 24, and that was about an interesting aspect in Swiss examination of patent applications at the Federal Patent Office. It was about the very basic question of how to assess technicality in Switzerland. So, of course, it's an implicit feature of an invention to have a certain technicality, and all the European patent attorneys just are yawning. I assume because the EPO has a very simple and straightforward approach that's sometimes called the any hardware approach. As soon as there is a thing mentioned in the claim which is hardware, then it's technical, and we are done with that part of the story, and all the rest is assessed when discussing obviousness. But the Federal Patent Office in Switzerland does it a bit differently because, and they say because they cannot assess obviousness, but they still are obliged to deal with the technicality. They apply what they call in German Ganzheitsbetrachtung, vaguely translated in English, it's a kind of holistic approach. We just look where the actual invention lies and then decide is that on the technical side or not. So the any hardware approach does not work in Switzerland, but they have this holistic approach. And here in that case, the applicant was not happy with that approach. The applicant was Swiss Re. I will just scroll down to the parties here. Where is it? It's here. It's Swiss Re against the Federal Patent Office, and that hearing, as I said, took place in March of 24. And yeah, we are awaiting that judgment, and I'm really eager to see that judgment, because let me be blunt here. I think that the current practice of the Federal Patent Office in that respect is. Yeah, it is wrong. That's not my understanding of what an invention is. Invention is just the what is the outcome of a creative mind, and if there is a thing included in that outcome, a wheel, even if it is a wheel that is known since 4,000 years, if the rest of the invention is just a business method carried out on wheels. The Federal Patent Office should grant a patent on that, as it would have to grant a patent on that wheel per se, because it's technical, and whether it's known or obvious, the Patent Office has no mandate to look at that. That's my 2 cents on that, but maybe I'm wrong again. But why I'm mentioning that is we got actually an order by the Federal Patent Office, and I will enlarge that one. That came in, I think, 1 or 2 days ago only, where we learned that a patent application that we are prosecuting at the Federal Patent Office, that proceedings in that case were stayed. We even requested accelerated examination. And the result now is that the proceedings are stayed. I wonder what happens to the fee that is charged for accelerated proceedings when proceedings are stayed. But that's a different story. But here it's only saying we are staying that case with reference to another proceeding where an appeal is pending at the Federal Administrative Court. No mentioning which case that is. My educated guess is that it's a case that I had on the slide before, but still, that's just an educated guess, and it's not mentioned in the order. The other thing I'm wondering, and there are a lot of things I'm wondering actually. The other thing I'm wondering is what's the legal basis for that? But I'm wondering about the legal basis at the EPO likewise. When the EPO president decides to stay proceedings in view of a case that is pending before the enlarged Board of Appeal, it's random that the president stays or does not stay, and I always wonder about the legal basis, and no one could convincingly explain to me by now what the actual legal basis is. But here, no legal basis is mentioned in that order, so the same question here. And yeah, and the final thing that makes me wonder is if there is an appeal case pending that the Federal Patent Office believes is really crucial for a certain basket of cases that are pending, then there should be a public notice that they are staying proceedings that essentially depend on that outcome, not just on a case-by-case basis without legal basis, and even mentioning the case that is pending at the administrative court. So that puzzled me a bit, at least. But yeah, so that now finally concludes the gossip section, and I exceeded the half an hour time that I typically spend on the fireside chat. So I hope you stayed with me until now, and I hope you enjoyed the session, and I hope to see you next month again, always last Wednesday of the month over lunch. So if you have questions, comments afterwards, just send me an email or leave a comment on LinkedIn. I have watched the comment section on LinkedIn. I think there were none, but in any event, if you have comments, questions afterwards, just let me know. I will be happy to pick it up bilaterally or in the next session. So thanks for joining this session again, and I hope to see you next month, the end of February, the last Wednesday of February. Thanks for joining, and bye-bye.